on improving outcomes for children and families. And we have our panelists here. We have the prosecutor is Kyle Bringhurst. Defense is Karen Jennings. Guardian ad litem attorney is Mike Elia. And counsel for the children is Krista Howard. Now, Kyle Bringhurst is a deputy prosecutor for Ada County. He's worked for the prosecutor's office for over 10 years. He's covered Child Protective Act cases full-time for approximately 6 years. He obtained his BA degree in International Studies from Utah State University and his JD from Brigham Young University. He is passionate about keeping children safe and making our community a safer place. He lives in Boise with his wife and sons and a dog. He enjoys his free time, fishing, hiking, spending time in the great outdoors. Now, Karen Jennings is an Ada County Deputy Public Defender assigned to Child Protection Team, which handles primarily child protection parent defense. She is board certified in child welfare law by NACC and prosecuted child protection cases in New Mexico as long ago as the early 1980s. She's been in Idaho for about 4 years, having moved here about 25 and here after 25 years in Alaska. Her legal experience spans almost 40 years and includes private practice, public defense, prosecution, and the Navy JAG Corps. Mike Elia was raised in Walla Walla, Washington. He graduated from Gonzaga University in 1984 with a Bachelor of Arts degree in history and a minor degree in computer science and finance. He received his Juris Doctorate from the University of Washington in 1987. He began his law practice in San Diego with an associate of McInnes, Fitzgerald, Rees, Sharkey, and McIntyre, where he emphasized in medical malpractice defense, general negligence, and automobile liability. In 1994, Mike relocated to Boise, Idaho, continued to develop his defense practice in areas of product liability, insurance coverage, commercial litigation, and construction law. First with Stoll Reeves, later with Brassey, Weatherall, Crawford, and McCurdy. In 2002, Mike went in-house as claims counsel for General Fire and Casualty Company. In 2004, he became a founding member of Lance, Elia, and Associates. In 2006, Mike joined his current law firm, now known as Moore, Elia, and Kraft, where he practices primarily insurance defense, represents state and local government entities in tort and civil rights action. Mike is admitted to practice before all state courts of Idaho, Washington, and California. He's also admitted to the United States District Court for the districts of Idaho and Southern California, and the United States Court of Appeals for the Ninth Circuit. Mike holds a certificate from the Northwest Institute for Dispute Resolution and Civil Mediation and is a member of the mediation panel of the United States District Court, District of Idaho. He holds an AV rating in Martindale-Hubbell and is a member of the Defense Research Institute, the Idaho Association of Defense Counsel, and the Federal Bar Association. Mr. Elia volunteers his time as the General Counsel for the 4th Judicial District Court Appointed Special Advocate Program and represents guardians ad litem in child protection proceedings. He enjoys skiing, golfing, and other sports involving a ball with his 3 sons, Noah, Daniel, and Joseph. Krista Howard is an attorney in solo practice for 22 years. She handles cases in Ada and Canyon counties as conflict counsel for the County Public Defender's Office in child protection actions, representing children, parents, guardians, and guardians ad litem. She also represents defendants on criminal cases for this county. I think I've got everybody. If you have any questions, just put them in the chat room and the panel will try and address them. And if you have technical difficulties, chat with Sam and she'll try and take care of them. Enjoy the panelists.
Well, thank you everyone for being here. A little intimidated by the number of people who decided to come to this panel. We appreciate you being here. I know there were a lot of interesting discussions and lectures on, so we appreciate your time. As you heard in the introduction, I'm Kyle Bringhurst. I'm a deputy prosecuting attorney for Ada County, handle Child Protective Act cases. And as you heard, I've done that for over 6 years now, and pleased to be here with Krista and Karen and Mike. I think we all have a lot of experience in this area and are very happy to take any questions you have. So feel free to put those in at any time, and we will be happy to address those questions. Maybe before we launch into our specific presentations, we could just briefly say how we got into working in Child Protective Act cases. Does that sound okay, Karen? All right, I'll go first. So I was working at the Juvenile Court, prosecuting juveniles for Juvenile Correction Act offenses in a spot open on the Child Protective Act team. And I really enjoyed working at Juvenile Court. I liked working on cases where the defendants were children, and they still, in my mind at least, had more of a chance to turn their lives around and were more likely to be put back on the right path. And so the Child Protective Act caseload kind of seemed like a continuation of that idea, which is trying to help kids earlier on before their lives get hopefully really tough and really difficult to correct some of those problems that we see in adult court. And so I like the idea of coming, and then turns out that once you come and work on the Child Protective Act team, you can't get out. They never let you leave. So I left for a year and now I'm back. So it's just further proof, but I do enjoy working here. It's a good group of people to work with. And I think we feel like we're making a positive difference in these cases. So that's how I got to be working here.
All right, I guess I'll chime in next. I have done child protection work in several states over many decades. I got involved in this actually in law school way back when they let me do an internship with the prosecutor in Albuquerque, where I was going to law school. I enjoyed it. I actually put the judge to sleep during my first hearing that I did. He fell asleep on the bench, and I had all my questions written out like you do when you're a law student. I was so prepared, and just yeah, that I don't think I've ever actually put somebody to sleep since then. I've done the work on and off for many years, probably more on than off for the last 20 years or so. I was a contractor for quite a while, a couple of decades up in Alaska, doing felony defense work as well as CP work and juvenile work. I believe, and when I moved down here to Boise, I wanted to do something that was useful and meaningful. And I don't think there is anything more meaningful than helping families figure out how to safely raise their children. And just because I'm a defense attorney does not mean that I don't know that there are safety issues with some families. And if we can work a little bit collaboratively together, that society will be better as a whole. And maybe some of those people who are felons, maybe some of those people as adults in jail won't be there if we can get some help to the families. That's, I guess.
Krista, you want to go or you want me to go?
Sure, I'll go ahead.
Okay.
So my name is Krista. I guess my bio is a little bit misleading in that I probably didn't write it very well. I've been in practice for 22 years, but not as a solo. In fact, that's only been the last 3 years. I started out as a public defender working in juvenile court, and then I did a lot of filling in with child protection at that time. And then I've also been on the other side with the Attorney General's office, and then returned back to the public defender's office, and always kind of in the back of my mind kind of felt like this pulling towards child protection, but kind of never really wanted to get back into it until I went out on my own. And it's definitely the place where I belong. I feel the most comfortable with as representing clients. there definitely are voices that need to be heard, and I just feel like that's been a good fit for me, and I think I do a good job, and I enjoy helping parents understand and navigating these cases. Sometimes they're complicated, sometimes they're not so complicated, but definitely working with parents and children, it's been challenging but rewarding. They definitely need to know that they have somebody on their side in these cases. And I feel like that's been where I've been most helpful. If nothing else, to help parents and children understand that their voices will be heard, and to understand how all of this plays out and what the goal is with all of these cases. And so the last 3 years, I've been working primarily in child protection, both in Ada County and Canyon County. I have done a little bit out in Washington County, but it is a rewarding area of law. Although when you tell people upfront what you do, everybody kind of goes, oh, which, you know, there are some bad things and bad cases, but it's really about helping these families get back together and finding, you know, their home together.
Very good. And I started doing child protection cases in 1994. My first 7 years in practice were down in San Diego, and I was looking at California's version of child protection, trying to find somewhere to perhaps volunteer. I didn't have any children of my own at the time. And then I moved here. I went to go work at Stoll Reeves, and it turned out that I've spent 2 years flying back and forth to California doing work down there. And so I guess my true confession, I just wanted to appear in an Idaho court and try to meet a judge and try to meet some other lawyers. And so I volunteered, and I guess the hook got set because I've been doing it ever since. As I continue to practice in Idaho and have been thankfully mostly here since 1996, and at least in terms of the practice, it bears saying, at that time, and I'm not sure I appreciated that until really this year, the child protection statute in Idaho was pretty young, and it was fairly undefined, and there was a lot of issues around trying to figure out everybody's role in that. And so the guardians, there's a lot of advice to give, and I got to learn it along with the guardians, along with a lot of other folks and the judges. And it's been very rewarding, at times frustrating, but all in all, you know, you see the difference you make for one child or many children, and it's worth it every time. So that's how I got here.
Thank you. Karen, I know you had a poll. Did you want to run that now?
That might be good, that we know who our audience is before someone gives their first talk.
Seeing a lot of other. So if you're an other, feel free to throw into the chat kind of generally what field you're in as well. Okay, people in home visiting, education, Juvenile corrections. All right. Well, it looks like other wins. So if you were other, you win a point. But there are no prizes, so the points are meaningless. All right.
Kyle, are you going to go first?
I can go first, because then get me out of the way, and then the people who know what they're talking about can go and clear up my mess. That'll be good. So I just kind of was going to give a brief overview of the Child Protective Act, and also specifically the prosecutor's role within the Child Protective Act. You know, the first thing to remember is that the Child Protective Act exists to keep kids safe, first and foremost. And it also secondarily exists to keep families together wherever possible, as long as that's safe. And so there's those two goals of keeping kids safe, and at the same time trying to keep families together or put them back together whenever possible. And so we work within that framework, all of us do. And we all kind of have that same legally mandated goal, which is to reunify families. So the prosecutor's office, I work for the Ada County Prosecutor's Office, and our goal, I think, just like every other prosecutor's office, is to see that justice is done, that the community is kept safe, that the law is followed, and especially in this field, to make sure that children are kept safe. And so I work on a team of 3 people that's specific to child protection. All we do is Child Protective Act cases. Most prosecutors' offices in the state of Idaho can't do that. They're not big enough. And so they're going to have someone maybe who is assigned to that, but they also do other things. But I think it's important for whoever is handling the Child Protective Act cases that they have some training, some background and experience, because these cases are not like your typical prosecutor responsibilities. When I started the prosecutor's office, I was doing things like DUIs and simple possession of drugs, or a lot of people driving without their driving privileges, driving on a suspended license. And those require a certain skill set, you know, to go in and prosecute those cases, but it's not the same necessarily as handling a Child Protective Act case. Child Protective Act cases are more cooperative, they're more collaborative, and they're more long-term. And so it is a specific skill set that we're lucky to have 3 people who are doing full-time, and we kind of help each other out on that. So the thing I guess I wanted to mention is that the prosecutor is kind of the gatekeeper on Child Protective Act cases. We file all the cases. Like some jurisdictions have the Attorney General's office do this work for them, but most of the jurisdictions in Idaho have a prosecutor that files the initial paperwork. So that means for a case to open legally, the prosecutor is going to go through the prosecutor. It goes through me or someone in my team here in Ada County. So the way those cases come to us are different. So most of the cases we get are from law enforcement. Police come upon a situation that they feel the children are not safe. They're in imminent danger of either abuse, abandonment, or neglect. And that they need to be removed from their parents' care. So they remove those kids, put them in temporary emergency shelter care through health and welfare. And then that comes to the state. If we don't file a petition under the Child Protective Act within 48 hours, excluding weekends and holidays, then those kids go back home. That case doesn't exist legally. It dissolves of its own volition. And so we have to then decide whether to file a petition. So what we do is we review police reports, talk to the police, talk to social workers, see whether or not we think it's necessary to file a case. In most cases, we almost always file a case because it is necessary. The police wouldn't have removed, in my experience, if it wasn't a serious safety concern. And so we decide and we file the paperwork and get that case moving forward. So that's most of our cases, and that's mostly what we do to start a case. But there are other situations where maybe the police don't think that the danger is imminent. There is a threat, there are concerns, but it's not an immediate safety concern. And health and welfare works with the family. And if the family then is not cooperating or the threats continue to grow, they can come to the prosecutor's office and say, hey, we think these kids are unsafe and we think they need to be put into foster care. And so that's another opportunity for us to collaborate with health and welfare. And so we'll have discussions with them about what's the situation, what are the safety concerns, what have you done to try to resolve the safety concerns, and if they can't be resolved, can we then bring these kids into foster care and prove to a judge that these kids are unsafe? And so we work with health and welfare on that, and then file paperwork with the court to see if we can get an order to remove children into foster care. And then the third way that a case would open would be through juvenile court. Anytime a child is in front of a juvenile court judge for whatever they're there for, beyond control, petty theft, whatever they're there for, if the juvenile court judge feels that this child is unsafe, they're being abused, abandoned, neglected in their home, they can turn their juvenile court case into a Child Protective Act case. And so they then have the child put into temporary shelter care with health and welfare, and then the case would come to the prosecutor's office. So even though a judge started the case, the prosecutor still has to decide to keep it open because we have to prove it at a shelter care. If we don't do that, then the case would be dismissed. So there's 3 different ways cases can open, but in each scenario, it comes to the prosecutor. One thing I think might be a misconception for some people is that the prosecutor's office or prosecutors are the big bad wolf, that we don't want people to get their kids back, that we don't want to work with families. You know, that nothing could be further from the truth. None of us, and as our judge always says, no one has an interest in having kids be in foster care. None of us here think that that's a good thing for kids to be taken from their families and put into foster care. Sometimes it's very, very necessary, but it's not the goal to put kids into foster care. The goal is to get kids into a safe situation and hopefully, as soon as possible, back with their parents where it's safe and appropriate. I think the issue sometimes that we have amongst the 4 of us and many other people who work in this field is that we can have different ideas about what is safe and what is appropriate for children. But that doesn't mean that we don't all have the same goal, which is for the children to be kept safe and hopefully to be with their parents. And so we do work with health and welfare towards that goal. Our relationship with health and welfare is a little interesting in the sense that we're not technically their attorney. A lot of times it could seem that way. It could seem like, oh, the prosecutor is the attorney for health and welfare because we collaborate with them. We work with them very closely. We file their reports for them. We consult on cases with them, give them advice about what we think the judge will do on a certain case, but we're not actually their attorney. We're representing the people of Ada County or the people of Idaho, and not necessarily the Department of Health and Welfare. And the Department of Health and Welfare, under the Child Protective Act, is not a party to the Child Protective Act. They are not a participant necessarily. The guardian ad litem's a party, parents are parties, the state is a party, but health and welfare is not. But they do have a lot of responsibilities under the Child Protective Act and a lot of things they're required to do. So it can be a little frustrating for them because they have responsibilities and obligations, but they don't have necessarily the rights of a party. So we work very closely with them. And I think it's a productive relationship where we help facilitate the things they need to convey to the court, information that they want the court to have, and we collaborate with them. A lot of times they will come to us and want something to happen in a case, and we have to decide whether we want to file the motions that would make that thing possible. And we don't have to because we're not their attorney. We're not directly representing them. But typically, in my experience, we have pretty similar views on things. And so typically we're going to be in agreement with health and welfare, but I've had plenty of times where health and welfare has wanted to do something on a case and I've had to tell them, no, I don't think that that's appropriate. It's a kind of an uncomfortable situation because we typically work very closely together, but that's something that the prosecutor is empowered to do, and we oftentimes do. One of the things as the case goes on that I've noticed over the years is that the most important thing is keeping communication open. Communication between all the various parties. And from the prosecutor's point of view, we need to be in close communication with health and welfare. We need to know what's going on with the case. We need them to tell us if there's problems, what they're planning on doing, so we can communicate that to the judge. We need to be in close communication with the parents' attorneys. If there's a problem, we can reach out to the parents' attorneys and say, hey, this is what's going on. A lot of times the parents' attorneys will reach out to us and say, we have this concern. Can we resolve it short of dragging everybody into the courtroom, filing motions? Maybe it's the kind of thing that a conversation can solve. And a lot of times we have been able to solve concerns and problems just by talking. And it's not necessarily legal work. It's kind of like social work in a way. We're working through problems, we're discussing things, we're mediating issues. But it's not all motion practice and legal filings that's solving a lot of these problems. It's just good old-fashioned communication. And sometimes that's hard to do, but for most of the people that work in the Child Protective Act cases that I've dealt with, they're open to communication. And when we have that open communication, it just leads to better outcomes for kids and families, and ideally quicker positive outcomes, because we're not just fighting for the sake of fighting, which certainly I've done on plenty of cases and I don't enjoy, but certainly we do it on occasion. But I've found that communication, respect, being open, those are the kind of things that are leading to better outcomes for children and family. Certainly the same is true with guardian ad litem attorney. We try to keep good communication with them. There are usually the guardian ad litem and health and welfare work pretty closely together, but sometimes they butt heads and they disagree, and that's good because they're independent agencies, they're independent participants in the Child Protective Act. We don't necessarily want them to be the same. And so when they have issues or disagreements, sometimes the attorneys can help them understand where the other side's coming from or what we need to do differently. But just having that communication, I think, helps. In cases where there's not that communication, these things just tend to fester and then they explode in an ugly way within the case. And that's never, almost never a good thing. Sometimes it's necessary, but it's certainly not enjoyable. I guess I wanted to share with you all, and then hopefully I was going to ask everyone else to chime in as well, on maybe what the most rewarding thing is in working in a Child Protective Act case, and also what the most frustrating thing can be in a Child Protective Act case. For the most rewarding thing from my perspective as a prosecutor is seeing, we open a case up, children are unsafe, we bring them into care, and then we see the parents make the changes that the judge orders them to make. They work hard and they make changes, and the kids who maybe weren't doing well start doing really well. And then we put the kids and the parents back together and they continue doing really well. And then we dismiss the case. That's amazing. I love it when that happens. And that's the most rewarding thing to me, is to see a family put back together in a much stronger position than they were when the case opened. We can leave people better than when we found them, and hopefully in a position where they're not ever going to come back into foster care, then that is super rewarding for me. The most frustrating thing as a prosecutor is probably those cases where for some reason I have a nagging feeling that this is not safe, but I can't prove it. So that doesn't happen often, but sometimes it does. And that's, the judge is going to send those kids home. If we can't prove they're unsafe, they're going to go home, and that's the way it should be. But it can be frustrating when you have a suspicion that you can't prove. That I would say is the most frustrating thing from a prosecutor's point of view. I don't want to bore everyone too much, so I'm going to stop there and let someone else go on, and then hopefully we'll have some questions at the end. Thanks, Karen.
Do you want us to answer your question, Kyle, as what's rewarding and
I think that would be good, just so
frustrating?
that we're not, it kind of breaks up the talking, but
Sure. I think for me, so I represent both parents, kids, and guardian ad litems, all in different cases. So at all different times. I will say, like, working with parents and kids. I think the biggest thing is their voices being heard. I think that parents express a lot of frustration when they're working with the department, and that they feel like they're not being heard or what they're doing isn't being appreciated. Because these are people that are coming from dysfunctional backgrounds. And so when I know for me, like, it's rewarding when a parent says, or when they do something and they get recognized for that by the department or by the judge. And it may be something very little, like making visits, all 4 visits in 1 month, or, you know, that they're making progress on maintaining a job or getting, you know, housing in order, and just feeling like they have been heard, and the court has heard them, the department has heard them, they're working hard. And so I think it's really rewarding to see them grow as parents in that role. Same with children, you know, they want to be heard. And I think a lot of times, I think children tell people in these cases, you know, what they think they want to, they say what they think that everyone wants to hear. But when they get to say what they really want, and then it gets relayed to the court through myself or their attorney, it's kind of like there's a proudness amongst the children, because they are getting to be heard on what they want too. I think the biggest frustration, though, is just personal biases that comes in from the different parties involved in a case, because everybody has an idea of what the perfect home is. And so when you have, every case has a different worker, so every case looks different. My home looks different than my client's home. My home looks different than Kyle's home, and same with the caseworker in the case. And so sometimes I think it's frustrating because there's this expectation that these homes are going to look so much better than what they started with. And it's hard to keep in mind that, you know, that's not going to be the home that this family goes to, although that's something to strive for. But it's just getting everybody to understand that this home, you know, is safe for the child, parenting is appropriate, their needs are being met, the family is communicating with each other, and, you know, they're loving each other. And so I think sometimes the frustration is trying to figure out what that looks like in each case, because it's not the same in each case, and trying to get rid of the personal biases of each party in the case.
I'll jump in. For rewarding, which is hopefully where we're all going to end up, or where these cases end up. I am on board with Kyle to see reunification, to see real change in families and those relationships, and see children who almost all uniformly just want to go back to their parent and just want to be back with their family. I would add to that, though, that there are cases where it becomes apparent pretty early on that is not going to happen. And to see outcomes, whether that's a guardianship with a relative in a safe place, whether that's ultimately a termination adoption, but to see these kids in a place where they can thrive in the future and grow is rewarding as well. For frustrating, I think I'd put time in that category. It takes time, and that's certainly understandable, but between court calendars, trying to make it all work with the caseload, all the parties who need to get together to do this, the attorneys who all are busy, and then the process itself, it takes an awful lot of time. And sometimes it just feels overwhelmingly frustrating that we're all aiming the same place and we can't get there. And it'll make you crazy, but it's worth it at the end.
Well, I guess it's my turn to chime in. I'm a defense attorney. There are a lot of frustrations. For those of you who aren't involved in the legal system, who don't know what defense attorneys do, I mean, our job is to zealously represent our clients. And our clients are not always reasonable. And that might be a big shock to people. And sometimes they don't want to listen to us as to what they need to do. And yet we need to represent them. Sometimes we end up filing motions that we know aren't going to fly. At least here in Ada County, I think one of the wonderful things that I'm very appreciative here in Ada County is that we have, the way it's set up, we have 3 public defenders who are assigned to the child protection team. And that's pretty much all we do. We do the private termination cases. And for some reason, we also do the contempt cases, which is a very different process here in Idaho than in some places. But primarily we're doing 90% of our work is child protection work. We have a judge who is assigned to us right now, and that changes all the time as to how it's mixed up between what are called shelter care hearings, which are those emergency hearings that have to be filed right away, and ongoing hearings and permanency hearings and termination trials. But we have one judge that does a lot of it. And I will say, I am so appreciative, having been in several states doing this work. It makes a big difference if you have a judge who, when you're sitting next to people who aren't sometimes all that functional to begin with, who have a lot of anger issues, are very resentful of the government interfering with their lifestyle and the way they like to do things, who doesn't browbeat your client, who doesn't shame them constantly, who gives them, some encouragement, as well as, telling them what the hammer is going to be if they don't cooperate. So that is one thing that I find very rewarding, is that as defense attorneys, we're being heard. We're not just being shut down. We're giving voice to our clients. And like I said, as a defense attorney, sometimes you have to give it the straight face test. Can you actually say this and at least look at the judge when you're saying it, and not hang your head? It's very different what we have to do. And part of my speech was, my presentation was going to be on what is the role of a defense attorney, and I can get to that more later. And I think, there are several frustrating things. Client control is always a big issue when you are a defense attorney. We are much, much more collaborative in doing this child protection work. And once in a while, you see private attorneys who don't do that much of this work that come in and try to treat this like it's a criminal case, and it's not. We have to be more collaborative. We tell information on our clients as far as what they've been doing and what they're up to, what their failures are. Maybe they had a relapse, and drug use is a major reason for children coming into care, because the parents aren't able to parent their children the way they should because they're stoned, or they're leaving their kids when they shouldn't be leaving them and going out to party. I mean, there's all kinds of different scenarios, and it can be frustrating, the client control issue. I'll talk some more a little bit later, but I wanted to keep that part short.
Well, do you want me to go ahead and talk about my role? So my role as an attorney appointed for children comes from the Idaho statutes, when a child is 12 years or older, they get appointed their own attorney. They may also be appointed a guardian ad litem. In some counties, attorneys are appointed to represent children under the age of 12, even because there are no guardian ad litems. The significant difference between the guardian ad litem, I think, and the child's attorney is what interest we work for. So as a child's attorney, when I meet with my clients' kids, I tell them that my job is to represent what it is that they want. And I make it very clear to these kids that I'm not concerned about what everybody else in the case wants, because I want them to understand that I'm going to court for them and to make sure that they are being heard. And I know oftentimes I run into attorneys that handle, that represent guardian ad litems. Mike is not one of them, but that don't do it very often, and they often question why I come into court not agreeing with the state, not agreeing with the guardian ad litem, not agreeing with the parents. And I tell them that that's not my job. My job is purely to represent the voice of the child, which is not necessarily what's in their best interest. I have children that never want to return home, and once they're removed from their parents, they're happy, they feel safe, and they've expressed that they don't want to return home. And it's my job to go to court and tell the judge and the other parties that this child does not want to go home. And that's typically contrary to what everybody else in the case is working towards, especially since the statute provides that reunification is to be the primary goal when these cases are opened up. I also have kids that come in that have been in horrible situations. They've been abused, they haven't been fed, they don't know where they're sleeping, they're not going to school, and they want to go home the next day because all they know is to be with mom and dad. And everybody else in the case is saying, well, this child needs to stay in care and we need to work with the parents. Again, I'm not concerned about what everybody else wants. My job is to come in and say, this child wants to go home, loves mom, understanding that it's not perfect, but that's where they want what they want. Working with children, it can be very challenging. I have cases where kids are very engaging and they call me. I have one client that calls me all the time just to say hi and chat with me and see how I'm doing. And she just checks in. I have some clients that I reach out to and want nothing to do with me, have never spoken to me, won't accept my calls. And I relay the message, that's okay. Here's my number. Call me whenever you feel like you want to call me. I'm here to answer questions. I have some kids that are kind of in the middle. They're not sure what my role is. We go over what my role is, and they're a little skeptical. And I think they're a little skeptical of a lot of people in these cases because they've been pulled out of their home. They've been pulled out of living with mom and dad. I find that for kids, some of them really connect with the guardian ad litem, some really connect with their caseworkers. But I also feel like what I've learned is that although there may be that connection with either the guardian ad litem or the caseworker, they're not necessarily also relaying how they truly feel about what's going on in these cases. I've seen where they'll tell the caseworker one thing and then tell me something different. And then we get in court and I tell the parties and the judge what the child really wants, which is contrary to what the caseworker just discussed with them the day before. And it's frustrating, I think, for a lot of the parties involved. I think this is where that frustration comes in from the kids, is that they're not being believed or being heard, which understandably occurs. I know one specific case where my client was telling the caseworker one thing and then telling me something completely different. I came into court and expressed to the parties what was being said. And the caseworker's like, well, that's not what this child was telling me. And I was like, well, that's what the child was just telling me. And so, you know, I think what's nice is typically the judges recognize that there's going to be different information relayed to different parties and can appreciate that because they are children. But I think it makes it hard for all of us involved sometimes. And I think they're children. I mean, you know, a 12-year-old doesn't know what a 12-year-old wants. One day they want to go home. The next day they don't want to go home because they you know, they like where they're at. Trying to ask a 12-year-old, where do you want to spend the next 6 years, 4 years, 5 years, you know, 1 year? It's a big question to ask a 12-year-old, and a 12-year-old shouldn't be making those decisions. I mean, that's just not a decision a 12-year-old should make. But because they are over the age of 12, you know, the judges ask them, where do you want to be? Where do you want this case to go? You know, if it's heading towards termination, do you want to be adopted by a new family, or do you want to be in a guardianship with a new family? Do you want to be adopted by your aunt, or do you want to be in a guardianship with an aunt? You know, that's a big question to ask a child between 12 and 18. And I think it affects them mentally, you know, significantly. But, you know, I always tell them when I have to have those conversations, you know, where do you want to be? Who do you want to be with? I always tell them it's okay not to know as well. Like, we can go into court and tell the judge, I don't know. I mean, I don't know that I would be able to make that decision. And so I find my job is to listen to them, to tell them I'm going to go into court and tell the judge whatever they want the judge to know, whether it's good or bad. One thing that I've noticed in the last year since we've gone to Zoom meetings, I feel like kids are able to express themselves a little bit more because they can participate in the hearings but not be seen. Whereas when we were in court, you know, if they came to court and they were asked questions, they were right there in front of all the parties. But on Zoom, they can black out their screen and they can watch the proceedings. Sometimes they like to engage, sometimes they don't. And I think that's been really, really helpful for some kids who want to know what's going on, but don't want to sit in the courtroom and be put on the spot or say something that may hurt mom and dad. Because I think what I hear a lot is, you know, I want this, but I don't want to hurt mom, or I want this and I don't want to hurt dad, which again, you know, that's got to be so hard for a child to process and deal with, on top of, you know, living in a different place. You know, maybe they've changed schools. I've got some kids that have been moved, you know, 10 times over 2 years. You can't even imagine what that's like. They've switched schools 3 or 4 times. And so I just feel like my role in these cases is really just to reach out to them. I let them know that they can text me, call me anytime they want. I answer my phone on the weekends. I've gotten calls at 10 o'clock at night from kids. I talk to them and I'm like, you know, whatever you got to say, you got to say. It may be really like little question. It may be a really big thing. Like, you know, today was just horrible. And I just kind of needed to hear somebody that was on my side. And I know for all of those people that are listening today, you all have such different roles, but such involvement with these kids. I know that a lot of them also report that there's a school worker that they can trust, or there's just somebody in the community, whether it's a counselor, a treatment provider that they really feel connected to. I mean, it's invaluable that they have all these resources that are provided to them through these cases. It's unfortunate, you know, that they're involved in these cases, but I think the gold lining is they meet a lot of people that really care for them and want to help them. And it always seems to be in every case, there's somebody that this child is able to connect with, whether it's the foster parent, the caseworker, the guardian ad litem. I know that the guardian ad litem really make connection with the kids, and it's really, I think, an awesome role for these kids to have these guardian ad litems. I know in Ada County, even though I'm appointed on kids that are older, most of them end up with a guardian ad litem. And I think it's fantastic because then they get 2 people that are, you know, talking to them, working for them, even though that the roles might be different. In Canyon County, it's the same thing. All the kids have both an attorney and a guardian ad litem when they're over the age of 12. And so again, they get the benefit of, multiple parties in addition to the department helping them out. And so there just really is a lot of benefit to all of us working for these kids. I know that in some cases I do get appointed for kids that are relatively young, some even infants, which really, as an attorney of an infant, there isn't much I really can do because you can't really have a conversation with an infant. But typically those cases also have guardian ad litems. But I know at one point in Ada County, when I first started doing this work, there weren't enough guardian ad litems to go around. And so I was being appointed on really young kids. It was kind of frustrating not to be able to really do anything for those kids because I wasn't a guardian ad litem. I was their attorney, and there's a distinct role. But since there's been an increase in guardian ad litems, it's been nice to see that all of these kids are now have their guardian ad litem as well as their attorney, and they get that representation from the guardian ad litem that's working in their best interest, but they also have their voice, and that's me coming in and saying, nope, I don't want that, or yes, I want that, and I can appreciate this, and just moving things forward. So that's kind of my role. I do work with parents a lot, and I will just add to what Karen said. Sometimes it's hard because I know we're all supposed to be working in the same, to reunify, but I will tell you that sometimes these cases are difficult because you don't want to be contentious because you're supposed to be working together, but it's so hard when a parent says, my kids have been taken from me and I don't understand why, and it's not right to not be contentious with the other parties, even though they're trying to work to get their kids reunified. It's sometimes a hard balance in working for your clients. But I do appreciate what Kyle said in that we all work together, and that is the truth, because the beauty of all of these cases, whether you represent the children or the guardian or the parents, is that the parties really do work well together, and there is a lot of open communication that you would never have in a criminal case or a civil case, because everybody is working to get this child reunified with their parent.
Okay, I guess it's my turn. I had a whole list of points and written out, but our makeup of our group is a little bit different than what I had anticipated here today. So I'm going to be winging it just a little bit. I can touch on some of the things that I had prepared. I guess one of the things to realize when we do these cases is, from a defense standpoint, parents have a constitutional right to parent their children, and children have a constitutional right to be raised by their parents, unless something has gone very wrong. And so generally speaking, we are working very hard to help the parents do what they need to do to be able to get their children back and to reunify, the end goal. That looks different some places, and sometimes the defense attorneys end up being the hard case with the parents. We're not social workers. I'm not a therapist, although part of what you do has to be part of that, and you let people vent, and then you tell them, well, you need to be nicer, you need to use some honey here. When you're working with people who are feeling people. I mean, our clients are often working mostly with social workers and the guardians ad litem, and they're not working with hardcore attorneys who can take a lot of abuse. I mean, after a while, they kind of give up and don't want to work with your client anymore. So some places, I haven't seen it done here in Idaho, but they have things like family group conferencing. They have restorative justice measures in some states, different programs that they've done. We don't have that here. So it's up to, sometimes I'll hear from a client and I'll hear from them for 25 minutes. And at the end of that time, I get out of it, well, they haven't had their visitation because of this, this, and this. And I'll shoot an email off to Kyle or one of the other prosecutors and say, hey, can you do something about the visitation? Just, so I can avoid filing some type of motion about reasonable efforts not being made. For those of you who don't know, that's one of the requirements of the department when children are in care and these cases are open, unless it's what's called an Indian Child Welfare Act case, which requires active efforts towards reunification, then it's reasonable efforts towards reunification. So I guess that, is one thing. One of the things that I also wanted to talk about that was on my previous list of things to talk about was to emphasize the fact that these cases are about the safety of the children. They're not necessarily about, are the children going to be better off in a middle-class foster home, looking at it from the big picture from an outsider. When we take into account the constitutional right to be able to parent, what's important is the safety of the children. And what you see sometimes is people who are involved in the case, and maybe this is one or two cases they're involved in, get hung up a little bit about the fact, oh gee, there's a leak in the roof. And a leak in the roof is not necessarily a safety concern that would impact the court's decision necessarily. Now, if the house was a fire hazard, yes, it does, but not a leak, in the roof. And sometimes you see some of that. And what we appreciate, and I also I wanted to mention, is when we have guardians ad litem, if they truly will engage with my clients, the parents, I won't stand in their way ever. I don't need to be there when they talk to my client. I like it when they actually feel comfortable enough to go see my client without the social worker. We expect that as social workers. They're trained to go out and deal with people who might not be middle-class people, who might not live in a nice, what we would consider a nice house. It might be a trailer that needs a lot of work, mobile home, whatever you want to call that. And we really appreciate that, an independent voice. And I tell my clients to cooperate with the guardians. They're supposed to be an independent voice and not, a rubber stamp for the department, because they're afraid of my client. And sometimes they're not nice people, but when you get to know them, maybe they'll be a lot nicer. I think one of the rewarding things is when the parents come to a realization that they do need to change. And sometimes it's a process and it takes a while. Sometimes you might not see them realize it until 4 or 5 months into the case. And typically we have 1 year for them to be able to reunify, and then they have to go to a permanency option that might not be reunification. It might be termination of parental rights and adoption. It is satisfying. I wouldn't call it rewarding, but it is satisfying when the parents come to the realization that their needs don't come first, that their children's needs need to come first, as long as they are children. And it might be, a sad thing to mention, but there are times when parents actually have matured enough, have gotten sober enough to realize that they really are not in a position to take care of their children long-term, at least for a number of years. And then they let, Aunt Annie, adopt their child, and they go ahead and agree to that. And then there's a sense of closure and satisfaction that their children will be well taken care of. I think at this point, maybe people want to ask a question or something. So, I would entertain a question or two, or maybe even for one of the other participants, if you want to post one. I don't know if we really have time to take a lot up, but I have a lot to say and I can go on, but let's hear from some people if you have questions. I guess I can keep talking since there's no questions. I see there's still names out there. People listening in. I think the communication issues are very, very important for the people that are working in these types of cases. One thing, it differs from jurisdiction to jurisdiction, and even within Idaho, from what I've been talked to, I used to have one place that I worked, we had professional GALs, and these people, of course, had separate opinions from the social workers, and they were actually on speed dial. I trusted their opinions. And when I had a very, very difficult custody case, or if we were thinking of fighting termination or couldn't figure out what to do with a client, I'd call up the GAL and say, what do you really think? Tell me. Let me talk to my client. What are we missing? What aren't we doing? That's helpful communication. And another thing that's a little different depending on your jurisdiction within Idaho is the direct contact between the social workers and the defense attorneys. I might be a big surprise, but sometimes I lose touch with my clients. They change their phone numbers. They can't access their emails anymore. And then yeah, I would just call up the social worker and say, hey, do you have a current phone number on my client? Here in Ada County, I know I do go through the prosecutor. I see we have a couple of questions here. There's one, what if the children come into the system more than once? Is reunification still a focus? I'll answer that very quickly, and then Kyle can probably chip in too. There are cases where kids come into care more than once. Depending on the reason that they've come into care, reunification is usually still an option unless some type of aggravated circumstances are found. And also the timeline for the reunification might be shortened. The federal law says that if the children are in care for 15 months of the last 22 months, that federal law requires that the state terminate parental rights and go towards adoption unless there are some type of special circumstances that are found by the judge. Yes, reunification is still a focus. It might be shortened. And also things tend to be a little bit harder on clients the second time through. One thing that is very, very sad, at least from a defense standpoint, is when you have a developmentally disabled client. And there are some people who truly cannot raise their children unless they're like living with a functional grandparent who is basically raising the children and they get to help. So there are times when you just can't. I'll let Kyle chip in too on that question.
Yeah, just briefly, the goal is going to be reunification when a child comes in for a second time until it's changed. And it's always reunification until it gets changed by the judge. But it can get changed a lot quicker if it's a second time or third time in foster care, either because of the timelines, like Karen said, if it's shortly after a prior case, or if the conduct is so extreme or repetitious or damaging to a child that the court can find aggravating circumstances. And really in that case is finding that a return home would just be an unacceptable risk to this child. So there's no point in considering reunification because of how terrible this repeat abuse or neglect is. That's not very common, but it does happen. I think, Mike, look like you'd come off mute. Are you ready to give your
Sure.
speech? All right.
Sure. First, I just want to say I very much appreciate being part of this and in the panel for those of you who don't know Kyle and Karen and Krista, they're really, really good people, really good lawyers. And I get to work with them in my volunteer work, and I appreciate that. For the guardian work that I've done, I've seen it in a couple capacities. One, representing the guardians, and that's been ongoing since 1994. And then programmatically with the 4th District, times with the 3rd District, in some iterations of what's going on in the 3rd District. I've worked as general counsel with the guardian ad litem programs, with the CASA programs, and try to advise from a more of a macro perspective. I think I've seen from different versions of the legislation, and also just from anecdotally the relationships between the program, between particularly CASA and health and welfare. Sometimes that's contentious, sometimes it's cooperative, and sometimes it's somewhere in between, but always, and then one of you mentioned this before, always working toward the same goals. And reunification certainly, and then the guardian ad litem's unique perspective, best interest. In thinking about this topic and the topic of the whole seminar, improving outcomes for children and families, and what's the guardian ad litem attorney's role in that, I really went back to guardian ad litem as attorney and counselor, and you see that sometimes on lawyers' cards. Attorney and counselor of law, and they're two very different things. So I went back and looked at the guardian ad litem statutes. It's Idaho Code 1633 and 1634, rights and duties, and they all kind of fit into one category or the other, oftentimes both. So when I think of attorney, I think as advocate and zealous advocate, as Karen said. And there are many times when guardian just has a completely different view of what's in the best interest than everybody else in the case. Being able to talk to the guardian, support the guardian, counsel the guardian, and ultimately advocate for the guardian is an important role. And there are times when, no matter how cooperatively we all are going to work together and do, we're not going to agree, and it has to go to court. And the only way for the court to make a good decision is for everybody to advocate for their side and get all the information in front of the court. And knowing that role, I think, is really important. The counselor part, I think, is much more difficult. And even though I've done this for a while, bottom line is I'm a volunteer. And this is an area that, although I've studied and I've gone to seminars and done some training, it's not my primary focus. That's not true for the rest of my panelists. And so I'm a little out of my league sometimes. And although I feel fairly comfortable in a courtroom, they have much more knowledge about this area of expertise. And Karen, I think you mentioned you've been in jurisdictions with professional guardians. There's also jurisdictions with professional guardian ad litem attorneys. And some, I think Arizona has deputy attorney generals who do that. And, I'm not sure how that works in other jurisdictions. But it's something I wonder about as we're looking to the future, where this is all going to go. And having either professional guardians or professional attorneys is something that may be coming down the pike across the country. But everyone's the same. I can tell you from my experiences with the 3rd and 4th primarily, and I have had a few cases in some of our other counties and districts, that the level of commitment and expertise that the guardians bring and the volunteer attorneys is impressive all in all. And I have very much appreciated that experience in going through this process. The one thing, and it's great to go last because then you get to chime in on some of the other comments. The relationship that the attorney has with the guardian, to be able to reach out to talk to the guardian. Luckily, I've had a few of these cases, so I can help the guardian sometimes, but also the guardian can help me. And whether the guardian can establish that tight relationship with the child or children, or whether the guardian ends up establishing a relationship with the teacher who has that relationship with the children, it's amazing the amount of information that the guardian can bring and should bring to the table. The guardian's separate order from the court that allows the guardian to get records that quite often nobody else can get, I think is also vital. And we as the attorneys can help in that process, whether that's just record gathering with the order or whether it turns out we need subpoenas to force the issue sometimes. Again, that's the advocate role, but that all helps in that process with the idea to get as much information to the court from as many perspectives, and certainly the guardian's untethered perspective of best interest of the child, which many times, not many, but sometimes is not the child's expressed interests. And some children get it and some don't, and some aren't old enough and some are. It's a tough process. And so I very much go back to thanking the panel and appreciate the chance to work with you. And I think some questions have come in while I was yakking, so I'll be quiet and maybe we can answer some of those.
There was one question I saw. Oh, Kyle, do you want to?
Yeah, well, I saw two questions, Karen. One was, what aspect of the Child Protection Act or laws would we change if we could? And then the other was taking into account, all the issues sometimes that are presenting in families, the traumas the parents might have had in their lives. Is a year really long enough to expect them to make change? So I guess I'd chime in on that just briefly. At a year mark, the judge has to make a decision about what to do in this case. But one of the decisions he can make is to give the family more time, give the parents more time. And he oftentimes does. The deciding factor usually is that parent making efforts to change? If they're actively trying and actively participating, our judge will usually give people more time, and he'll give them sometimes a whole nother year to keep working if they're actively working and making progress. But it is a good question. The counterpoint to that is, how long should children have to wait in uncertainty before they get some sort of certainty and permanency in their life? And that's the counterbalance the judge has to decide. How long should I hold these kids out in limbo before I make a decision? And if they're moving in a positive direction, he'll oftentimes give that extra time. If there's not progress, then sometimes the judge will not think that it's appropriate to keep kids kind of dangling out in limbo with the hope that maybe someone might change in the future. Maybe they will, maybe they won't. But if they're showing that effort and that progress, even if it's small progress, a lot of times the judge will give additional time to families. So hopefully that answers that question. As to what aspects we would change, I'm going to throw this to Karen because she always is telling me all the great ideas she has about things she thinks would be better.
That's part of the problem of having practiced a lot of different places. I'll try to make it really short. I think the one thing that I'm most disturbed by from a legal standpoint that I would change if I could would be how we handle the CP interaction with juvenile justice. There was a House bill that recently passed it passed the House. I don't think it's passed the legislature yet. Somebody in our office was keeping tabs on it. I think we are penalizing sometimes in branding certain parents as being neglectful or abusive when they can't take an offender back in their home. You have a 16-year-old, sexual offender who perpetrated on a sibling, and they just can't have that child back in the home. So they're branded as being neglectful, unstable home or whatever, so that the CP system can find them a place to live until they're old enough. I think that's pretty horrendous for some parents who are really trying, and it's not their fault that their child has gone sideways. That's a good first step. I used to advocate for juvenile justice foster homes, which we do not have here that I know of, so that we could keep the kids totally out of the CP system and they could stay in the juvenile justice system. So anyways, that was the one thing. And then I'll very briefly on the question about the permanency issues. Some states are not nearly. Idaho, the reunification, when I first moved here, the services in place for the children, I'd never seen any other state other than Oregon who put the system in place for reunification that we had here in Idaho. But we're also very efficient here, which means when we get to that 1 year mark, it's not like these cases are going to dangle out there 3 years like they often do in other states. We get to that 1 year mark, we have a hearing, and the judge, makes the decisions that he needs to make. And so it's probably a little bit of a two-edged sword that we are as good as we are, and the court system works as well as it does here. It's phenomenal the way it works here in Idaho. And so I'll be quiet and let everybody else.
Karen, I think the question came in, do you know what House bill that is regarding the juveniles?
It looks like it's 233. I'm looking at an email that I got the other day.
Great. If I could change one thing, and I'm not sure it'd be a blessing or a curse. It would to give guardian ad litems the ability to chime in more on permanency, whether that's ultimately back with the parent, termination, adoption with foster, where that is and who that is under our current system. Until just recently, health and welfare had sole discretion on that, at least under a Supreme Court ruling. Legislation clarified that so that we now know the judge ultimately has that decision. But it is, I'll go back to the comment I made right at the beginning. It's the time, it's frustration, and having a goal of permanency as quickly, as reasonably as possible, and to give the guardian some role in that, a bigger role in that, I think would be something I would change. I think you'd have to change a lot of things along with that. But it's certainly something that I would want looked at if I could. Krista, I think it's to you.
I don't know if I can think right now of, well, I guess, what law. Two of the things that I think are a little frustrating is the lack of consistency throughout the state. And I think that's, the law is what the law is, but it's applied so differently from county to county. And for me, it's frustrating to go, from one courthouse to the next courthouse and have the judges handle something very similar so differently, knowing that, like, if I go into court for one child in Ada County and ask for something or present something in another county, that child may not, like, it won't be treated the same way. And I think that's, so I don't know necessarily that's the law. I also sometimes think, I know that there are very specific timelines in the statutes. And sometimes I think they're a detriment. I know for the most part they're good, but like with, when I see kids that are home on an extended home visit pretty quickly when a case opens and the case still lingers, 6 or 8 months later because we're following timelines, I think that's a little frustrating for the families in the cases. And that's rare. I mean, obviously a child that goes home at shelter and then, we can't really start anything until adjudicatory or, so there's kind of that lingering following the timelines. That's kind of my only, I don't know how you change that, but sometimes I think that the 90 days on an extended home visit, if there were a way to waive it because the child's been at home since day one, but we're still like, I know the judges want kids out as fast as they can get them as long as they're safe, but sometimes I feel like those timelines hold us back a little bit.
And I don't know that I have anything to add as far as things I'd like to see changed. It's always kind of a scary proposition because you change something and it's going to have major unintended consequences. But I would echo, I think, what Karen was saying about there are some cases that don't really fit the traditional view of like a neglectful parent, but it's a parent who cannot have their child in their home because of the child's criminal or juvenile violations that make that child unsafe to be around other children. That's a frustrating circumstance because there's not really a lot that can be done to fix it either. The goal of the Child Protective Act is to put a plan in place that can resolve concerns and get a child back home. But in some cases, those concerns cannot be resolved if the offender and the victim are both children of the parent, and at least they're not something that we can resolve through a Child Protective Act case. So it'd be nice if there was some other mechanism to keep those kids safe. But until there is, we'll just keep doing what we can to keep them safe under the Child Protective Act. I think we're just about out of time. So if there's any last minute questions, but I've appreciated all the questions and the great comments from the rest of the panelists.
I'd like to thank all of you panelists for participating today. It's very nice you would come out and do this. Also, to those listening, please complete your evaluation forms. It's very much appreciated. It's very helpful. And unless there's another question, I think we're done a little early, 4 minutes.
Perfect. Cheryl, I want to say thank you for you appearing from the beach. I know you probably would rather be out there surfing, but thank you for joining us.
Yeah, that would be nice. All right. Bye, everybody.